Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here to give a lecture on risk of loss and warranties in sales transactions. And we're going to help you better understand the protections and obligations that exist in commerce. Our agenda will be talking about passage of title and risk of loss and special problems that exist in that area. Express and implied warranties will be discussed, as well as the Magnuson-Moss Act and the warranty types available there. We'll look at exclusion of warranties, persons covered under warranties, and the remedies for breach, and then look at some practical applications in the end. So, passage of title and risk of loss. We're here talking about legal ownership and risk of loss concepts, including void and voidable title transfer rules, insurable interest for sellers and buyers. So contracts aren't just promises. They allocate real-world risk. And people often think contract law is just about offer, acceptance, and consideration. But in sales of goods, the real question is, if something bad happens to the goods, who pays? Well, risk of loss rules will answer that. Title and risk of loss determine who bears the loss when goods are damaged. So if goods are destroyed in transit or stolen from a warehouse or damaged before delivery or lost by a carrier, someone has to absorb that loss. Title and risk of loss rules decide whether it's the buyer or the seller, and this is the practical side of contract law. Title affects rights against third parties. Who can insure the goods, who can sue a carrier, who can pass good title to someone else, whether good faith purchaser is protected. And these questions all hinge on who has title and when it passed. And risk of loss connects directly to shipping terms. So when you see the terms like in the previous lecture, FOB seller's place, FOB buyer's place, shipment contract, destination contract. These aren't just vocabulary words. They determine who pays if the truck crashes. Insurable interest depends on identification and title. And so to understand insurable interest, you need to know when goods are identified, when title passes, when each party has a stake worth insuring. And so this is going to tie to the UCC's concepts together. So void and voidable title transfer rules. If persons with a void title attempt to transfer title, they transfer only void title. No title passes, and the buyer gets nothing because the transfer was never legally valid. An example, like a stolen laptop someone sells on Craigslist. A thief steals Maria's laptop and sells it to Jordan, who pays full price and has no idea it was stolen. So Jordan gets no title because a thief cannot pass title they never had. And so Maria can recover the laptop from Jordan. So a good faith purchaser cannot acquire title from a thief, and title is void from the start. What about a forged signature on a car title? So Sam's Someone forges Sam's signature on a car title and sells the car to a buyer. The buyer believes the paperwork is legit. And no title passes, though, because a forged signature means the transfer didn't occur. Forgery equals void title. The true owner keeps ownership. Another example is sale by a person pretending to be the owner. A con artist, for example, breaks into a storage unit and pretends to be the owner of a vintage guitar, and they sell it to a music shop. And the shop gets no title because the seller had none. So possession does not equal ownership. Only the true owner can transfer title. If the person who has a voidable title transfers title to a good faith purchaser, the transferred title is valid. Title passes at first, but the original owner can rescind because the transfer was flawed. So let's say the buyer pays with a bad check. So Taylor sells a TV to Chris, and Chris pays with a check that later bounces. Chris has voidable title. Taylor can rescind the sale, but if Chris sells a TV to a good faith purchaser before Taylor rescinds, the good faith purchaser gets good title. So fraud in payment creates a voidable title, not a void title. What about a sale induced by misrepresentation? A buyer lies about their identity or creditworthiness to convince a seller to part with a car and get that car up. And the seller voluntarily hands over the car and title. And so buyer has voidable title because the seller intended transfer ownership but was tricked by the buyer. So intent to transfer plus fraud equals a voidable title. What if a minor purchases a motorcycle? If a 17-year-old buys a used motorcycle from a private seller, the minor has voidable title because minors can disaffirm contracts. If the minor sells the motorcycle to a good faith purchaser before disaffirming, the purchaser gets good title. So capacity issues create voidable, not void title. And some of this should all be sounding kind of familiar by this time if you've been listening to some of the previous lectures. Next, we look at insurable interest for sellers and buyers. So what is insurable interest? Insurable interest means a party has a legal and economic stake in the goods such that they would suffer a loss if the goods are damaged or destroyed. It prevents people from taking out insurance on property they don't actually care about or own. And under the UCC, ownership is not the only way to have an insurable interest. Buyers insurable interest because buyers have insurable interest before they receive the goods. So a buyer obtains insurable interest when the goods are identified in the contract. And identification occurs when the seller sets aside specific goods for the buyer. The contract specifies unique goods. The goods are marked, tagged, or otherwise designated for that buyer. And this matters because the buyer can insure the goods even if the seller still has possession. And if the goods are damaged after identification but before delivery, the buyer may recover under their insurance policy, depending on risk of loss rules. So, for example, a furniture store tags a specific sofa as sold to Alex. Even though Alex hasn't picked it up, Alex now has an insurable interest. And the seller's insurable interest sellers also retain insurable interest in certain situations. So a seller has insurable interest as long as they retain title or a security interest in the goods. And so this happens when the seller ships goods on credit, or the seller retains security interest until payment, or the seller is responsible for delivery under the contract. So this is important because the seller can insure the goods to protect themselves against buyer non-payment, damage while goods are still in seller's possession, damage during transit if the seller bears the risk of loss. So an example here is a seller ships goods FOB, buyer's warehouse, and the risk stays with the seller until delivery. The seller retains insurable interest, but the goods reach the buyer. Until the goods reach the buyer. So also it's entirely possible and it's common for both buyer and seller to have insurable interest simultaneously. And this overlap protects both sides during the period between identification and final delivery. For example, goods are identified to the contract and the seller still holds them pending shipment. And the buyer has insurable interest because of identification. Seller has insurable interest because they still possess the goods and may retain title or security interest. It connects this is a way we connect contract formation to risk of loss, title, and remedies, and why insurance companies require proof of an economic stake in the matter, in the property or the goods. So title is not the only controlling factor under the UCC. In fact, identification is. Next, we're going to look back to shipment and destination contract rules and put this together in terms of risk of loss. So shipment contract rules. Title and risk of loss pass to the buyer once the goods are placed on carrier for shipment. And title and risk of loss remain with the seller until goods reach the agreed destination and are received by the buyer. When delivery is not required, title and risk of loss pass at the time the contract is made. And if the buyer rejects the goods, title may revert back to the seller, which affects ownership and risk. Next, we're going to look at ways of creation of express warranties and how they're formed. So an express warranty is a promise, description, or affirmation of fact that the seller makes about the goods, which becomes part of the basis of the bargain. If the goods don't live up to that promise, the seller has breached the warranty. It must be an affirmation of fact, description, sample/model. So some examples. This laptop has 16 gigabytes of RAM. This ladder can support 300 pounds. This paint is mold resistant. So these are samples that represent what the buyer will receive. And they create an express warranty because they're factual claims. Know that no special words are required. The seller doesn't need to say, I warrant or I guarantee. If the seller makes a factual promise about goods, it counts. Opinions and puffery do not count in express warranties. Statements like, this is the best truck on the market. Top quality craftsmanship. You're going to love this. These are all sales talk, not warranties. The warranty must be part of the basis of the bargain, and it simply means the buyer relied on the statement when deciding to buy. Implied warranties have a really simple definition. An implied warranty is a warranty that arises automatically by law, even if the seller never says a word about the quality of the goods. And these warranties exist because the UCC assumes certain minimum standards in a commercial sale. So there are two main types of implied warranties. Implied warranty of merchantability is covered under UCC Article 2, Section 314, and applies only when the seller is a merchant of goods of that kind. So the goods must be fit for the ordinary purpose which the goods are used, and they have to be of fair or average quality and properly packaged and labeled, and they have to be labeled consistent with the kind and quality, and they have to be free from significant defects. So, for example, a merchant sells a new toaster, and it should be it should toast bread safely and normally. And if it catches fire on the first use, the seller breached the implied warranty of merchantability. We also have implied warranty of fitness for a particular purpose covered under UCC 2-315. This applies to any seller, merchant or not, And what it means is a warranty arises when the buyer has a particular purpose, not just ordinary use. The seller knows about that purchase. The buyer relies on the seller's skill or judgment to select suitable goods. So here's an example. A buyer says, I need paint, like in paint for construction paint or whatever, that will work on wet concrete. And the seller recommends a specific paint. If the paint fails because it wasn't suitable, the seller breached the applied warranty of fitness. Some things don't create an implied warranty, like a garage sale, as-is sales, if they're properly disclaimed, or casual sellers who are not merchants in terms of merchantability, and pure puffery or opinions don't count. Next, we're going to look at the Magnuson-Moss Act and warranty types. So the Magnuson-Moss Act applies to consumer products and governs written warranties. When a seller or manufacturer gives a written warranty, they must label it as either full or limited. And this helps consumers understand what level of protection they're getting. A full warranty gives consumers the strongest protection. And to qualify as full, the warranty must meet all of the following requirements. Free repair or replacement. The warrantor must fix the product without charge, including parts and labor. The second is no unreasonable limits. They can set a time period, for example, 1 year, but they cannot make the consumer pay for coverage during that period. No limitation is available on implied warranties. So implied warranties cannot be disclaimed during the full warranty period. And also, consumer gets a refund or replacement if repairs fail. So if the product can't be fixed after a reasonable number of attempts, the consumer must get a refund or replacement. And warranty applies to anyone who owns a product during the warranty period, not just the first purchaser. And there's no requirement that the consumer perform burdensome tasks. For example, the warrantor cannot require the consumer to pay the shipping or return the product in original packaging. Limited warranties have some key features. A limited warranty is anything that does not meet the full warranty requirements. So commonly, only parts are covered. The common limitations mean that only parts are covered, not labor, like the parts of a car versus the labor that's required. But instead, and then they'll limit it to only certain components being covered, or the consumer may pay shipping or diagnostic fees. Warranty applies only to the original purchaser. Warranty excludes certain types of damages. Warranty limits the number of repair attempts. But so in short, a limited warranty gives some protection, but the seller can place restrictions on what is covered and how. So next we're going to talk about the seller's right to exclude warranties and the requirements for an effective exclusion. So even though the UCC automatically gives buyers strong protections in merchant sales, sellers do often try to exclude or limit warranties because warranties create risk, cost, and legal exposure. Excluding them shifts the risk back to the buyer. The sellers exclude warranties in merchant transactions because warranties create legal and financial risk, and excluding them shifts that risk to the buyer. So every warranty, express or implied, is a promise. If the goods fail, the seller can be sued for breach of warranty, refund or replacement, consequential damages, sometimes that's using care, and attorney fees in some cases. And merchants exclude warranties to reduce the number of ways a buyer can sue them. Warranties are expensive. If a merchant keeps warranties in place, they may have to repair defective goods, replace defective goods, pay for shipping or labor, handle customer claims, and for high volume or low margin businesses, this is a major cost. And buyers sometimes use goods incorrectly, or modify them, or overload them, or ignore instructions. And if warranties remain in place, sellers may be blamed. And so excluding warranties helps sellers avoid being responsible for how the buyer uses the goods. Implied warranties are broad and hard to control. So implied warranty of merchantability requires goods to be fit for ordinary use, free from defects, properly packaged, consistent in quality. And those are big promises, and it applies automatically, and many merchants exclude it because they don't want to guarantee every aspect of the product. So how do we avoid the implied warranty of fitness? Fitness for a particular purpose, for example, arises when the buyer has a special purpose and the seller knows the buyer is relying on them. And merchants often exclude this because they don't want to be responsible for specialized uses they didn't intend. Well, I don't know quite where I was when I had to pause. It is again that time of day, but that was not a trespasser like I get sometimes with the dog barking for. That was a legitimate homeowner that came home, and it's New Year's Eve, so Happy New Year. 2025 and 2026 is tomorrow. So let me see if I can remember where I was. I think I was at some of the legal implications. So to limit exposure in used, refurbished, or clearance sales, for example, that's where merchants are selling used goods, refurbished goods, open box items, clearance or scratch and dent products. There's often exclusion of warranties because they cannot guarantee the quality. We also have Magnuson Moss that comes along. If a merchant gives a written warranty on a consumer product, a federal law called Magnuson Moss, we've talked about that, imposes strict rules. And many merchants avoid these obligations with practices like giving no written warranty or giving a limited warranty and excluding implied warranties. And this also will require looking at state law to see if the state applies. So this keeps them out of the full warranty requirements. All right, so now we get to the requirements for effective exclusion. It's pretty simple. Effective exclusions must be clearly documented in writing to be enforceable and valid. And the exclusion must explicitly mention the merchantability to clarify the terms involved. And exclusion clauses must be conspicuous within the document. So you use bold, underline, or capital letters. As in this picture, they're even highlighted in yellow. All right, so we're going to look next to warranty coverage beyond privity in UCC alternatives. And this, we're going to have to remember there are state versions that we need to pay close attention to when we're dealing with warranties. So privity limits who can sue for breach of warranty, but modern law, especially the UCC and Magnuson Moss, have expanded warranty coverage to protect more users, not just the original buyer. So just to work with vocabulary, privity means a direct contractual relationship between two parties. And traditionally, only people in privity could sue for breach of warranty. For example, buyer purchases a toaster from seller. Buyer is in privity with seller, and buyer can sue the seller for breach of warranty. So it used to matter historically because only the direct buyer could sue for breach of warranty. And family members, guests, or later purchasers couldn't sue because they weren't part of the contract. And what happened there was unfair results, especially when defective goods injured people who never signed the contract. So there's expanded warranty coverage, and that expanded warranty coverage refers to situations where warranty protection extends beyond the original buyer or beyond the original written terms. And so there are some main ways coverage expands. One is third-party beneficiaries, because again, there's no privity. Without privity, under the old law, the more historic law, warranties didn't extend. So they didn't, let me start that over. Even without privity, warranties can extend to family members, guests, employees, anyone expected to use the goods. And so this was how the UCC built in expansion of warranty protection. All right, a buyer, another is manufacturer warranties. A buyer may purchase from a retailer, but the manufacturer often provides the warranty. So you buy a laptop from Best Buy, the warranty comes from the product maker, like Hewlett-Packard or whatever. You can sue Hewlett-Packard even though you have no contract, that is, with Hewlett-Packard. This is what we call the major privity exception. And back again to the Magnuson-Moss Act. For consumer products, Magnuson-Moss requires clear labeling of warranties, both full and limited, we covered this in the previous slide, and prohibits certain disclaimers and allows consumers to sue manufacturers directly. So this is an expansion beyond the immediate seller, which was part of the privity thing. Extending service contracts. And so these are not technically warranties, but they do have a function like them. They expand coverage by adding years of protection, covering additional parts. This is when I buy things on Amazon, it'd be the stupidest little thing, and they want to know if I want an extended warranty on a toaster that I'm paying $12 for. I don't do that. I don't spend my money on it. But anyway, even though they're contracts, not UCC warranties, they broaden who can get repairs or replacements. And lastly, assignability and transferability. In some cases, a warranty can allow transfer to a second buyer, transfer to a family member, transfer upon resale of the product. So this expands warranty protection beyond the original contracting party. So again, the idea is that privity involves that direct contractual relationship between parties, but expanded warranties and the laws surrounding them have broadened those protections to other people. All right, so we're going to look a little bit on the state versions where we can. So the UCC changed privity, as I just pointed out, and allows to expand warranty protections. And the states can choose among three alternatives. So just the idea. Household and family members, so anyone in the buyer's household who is injured by the goods can sue. Again, this is stuff that happens in the state law level. Any natural person expected to use the goods, and any person, including corporations, expected to use the goods. That's really one of the broadest versions of extended warranties. The bottom line is most states today do not require strict privity for warranty claims involving personal injury. All right, so what are our remedies for breach of warranty? When a seller breaches a warranty, the UCC gives buyers a full toolbox. They're reject, revoke, cover, get damages, including general and incidental and consequential, and in rare cases, they can force performance. So when a seller breaches a warranty, the UCC gives buyers a menu of remedies designed to put them in as good a position as if the goods had been warranted. So the major remedies are damages for breach of warranty under UCC 2-714. This is really the core remedy, and it's a general measure of damages and determined by the value of goods as warranted minus the value of goods as delivered. In plain English, how much less are the defective goods worth compared to what was promised. So if you buy a new laptop that turns out to be refurbished, or a waterproof jacket that leaks, or a 300-pound capacity ladder that bends under normal use. Incidental damages are covered under UCC 2-715 subsection 1. And these are reasonable costs the buyer incurs because of the breach. And some examples include shipping defective goods back, paying for inspection or testing, and covering the costs of obtaining substitute goods, or storage for handling fees, if you think of these of cleaning up, just kind of housekeeping of the breach. Consequential damages are covered under UCC Section 2715 subsection 2. And these are losses that flow from the breach and were reasonably foreseeable. Some examples are lost profits because a defective machine shut things down, and production couldn't go forward, damage to other property caused by the defective product, this is in many states, also provide personal injury, as we were talking about in the previous slide. And this is where there's warranty law overlaps frequently with tort-like claims. A right to revoke is another one. The defect, it's covered under UCC Section 2608. If the defect substantially impairs the value of the goods, the buyer can revoke acceptance. So revocation can be allowed if the defect was hard to discover at first, or the seller promised to fix it and failed. After the revocation, the buyer can return the goods, recover the purchase price, or seek damages. And this is what you call the I want my money back remedy. And they have the right to reject the goods under UCC Section 2-601. So if the buyer discovers the breach before accepting the goods, they can reject them entirely. And this is based on the perfect tender rule, which means if the goods fail in any respect to conform to the contract, the buyer can reject. And after rejection, the buyer can cancel or cover, which is cover means, remember, is to buy substitutes, or seek damages, or all of the above. What is cover? It's covered under UCC Section 2712, and the buyer may purchase substitute goods, recover the difference. Cost of cover minus contract price is how that's handled, plus incidental and consequential damages. And so the cover is the UCC's way of encouraging buyers to solve the problem quickly and keep commerce moving. Refund or replacement, and this is often by warranty terms. If the seller provided a written warranty, especially under the Magnuson-Moss, the buyer may be entitled to repair, replace, or refund. A full warranty requires refund or replacement if repairs fail. This is a contractual remedy layered on top of UCC remedies. And then specific performance, which is rare but available only when the goods are unique, like in art, antiques, rare items, or cover, rare items. And cover is impossible because it's rare item, one of a kind. This is the court forces the seller to deliver the goods remedy. So as a prerequisite to a lawsuit, plaintiff must notify the seller of the defect, and the UCC provides statutory remedies, like I was just talking about, when the warranty has been breached, and incidental and consequential damages, along with those others that I mentioned above, are also included. When a consumer has warranty rights under the UCC, again, we're going to look at some of the overlap with tort, including strict liability. So when a consumer has warranty rights under the UCC or the Magnuson-Moss, they also have independent tort rights. And tort claims don't depend on privity, disclaimers, or contract terms. They exist to protect people from unsafe products, not just broken promises. So strict products liability, which is covered under both of, you can look at the black letter in restatement section 402A and modern state law. So this is the most powerful tort remedy. A seller is strictly liable when they sell a defective product. The defect makes the product unreasonably dangerous, and the defect causes injury. So what kinds of defects might we be considering? A manufacturing defect, where a product departs from its intended design, a design defect, the design itself is unsafe, or failure to warn, where missing or inadequate warnings have not been included. It's important because there's no privity required, and there's no need to prove negligence. And warranty disclaimers do not block strict liability. It's the consumer's strongest protection, actually. Negligence, a consumer can sue if the manufacturer or seller failed to use reasonable care when they designed the product, manufactured it, inspected it, tested it, packaged it, failed to warn about dangers. And it's important because it covers a wide range of careless conduct, allows recovery for personal injury and property damage, and it's not limited by contract disclaimers. Negligent misrepresentation also needs to be covered. If a seller or manufacturer carelessly provides false information about a product and the consumer relies on it, they can sue in tort. Some examples: a salesperson gives incorrect safety information, or a manufacturer publishes misleading specifications. And then fraud and intentional misrepresentation. If the seller knowingly lies about the product, the consumer can sue for fraud. So hiding known defects, falsifying safety tests, marketing a product as safe when the company knows otherwise. So fraud damages include punitive damages, so there's broader recovery and claims even when warranties are disclaimed. All right, some practical applications about this and sample language for title and risk of loss and warranties and exclusions. So understanding how title and risk of loss affects loss transfer affects sales and ownership is important for the paraprofessional to know about as they're analyzing contracts, helping to draft them. And sale on approval allows the buyer to inspect goods before the title and risk transfer is finalized. So you might insert that language into the contract. Types of warranties, we talked about these, and the warranty combinations, warranty exclusions and notices, and contract types. Remembering language that we can use from form books and other locations, so that we have covered the situation either to be compliant with the law or to make contracts less risky for the seller, for example. Would be something that we do as a paraprofessional, or obviously lawyers. So hope you've enjoyed this exploration where we've looked at some of the key aspects of risk of loss and warranties and sales transactions, including transfer of title, special risk situations, and legal protections under the Magnuson-Moss Act. So understanding the exclusion rights, warranty coverage, and remedies for breaches will help you more effectively draft clear contractual language for making secure transactions. Thank you.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that: mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.